Resolution Section 4 Resolution of Investigating Prosecutor and its review. An investigating prosecutor finds cause to hold the respondent for trials. He shall prefer the resolution and information. He shall certify under oath and the information that he or assumed by the record. An authorized officer has personally examined the complainant and his witnesses, that there is reasonable ground to believe that a crime has been committed and that accused is probably guilty thereof, that the accused was informed of the complaint and of the evidence submitted against him, and that he was given an opportunity to submit controverting evidence. Otherwise, he shall recommend the dismissal of the complaint within 5 days from his resolution. He shall forward the record of the case to the provincial RCT prosecutor or chief state prosecutor or the ombudsman, or he is deputy in cases of offenses punishable by the Sandigan Bayan and the exercise of its original jurisdiction. They shall act on the resolution within 10 days from the receipt thereof, and shall immediately inform the parties of such as action. No complaint or information or filed or no complaint or information may be filed or dismissed by an investigating prosecutor without a prior written authority or approval of the provincial RCT prosecutor and chief state prosecutor are the ombudsman and his deputy. Where the investigating prosecutor recommends the dismissal of the complainant, but his recommendation is approved by the provincial RCT prosecutor or chief state prosecutor, or the ombudsman are his deputy, on the ground that a probable cause exists, the letter by himself file the information against the respondents or direct another assistant prosecutor state prosecutor to do so without without conducting another preliminary investigation. If upon petition by a proper party under such rules as the Department of Justice may prescribe or motu proprio, the Secretary of Justice reverses or modified the resolution of the provincial or city prosecutor or chief state prosecutor. He shall direct the prosecutor concerned either the file corresponding information without conducting another preliminary investigation, or to dismiss or move for dismissal of the complaint or information with notice to the parties. The same rule shall apply in preliminary investigation conducted by the officers of the Office of the Ombudsman. By the Office of Ombudsman. Office of Ombudsman. Office of Ombudsman. Ombudsman. Sector 5. Relation of investigating within 10 days after the preliminary investigation. The investigating judge the provincial prosecutor or to the ombudsman of his deputy in case of offenses cognizable by the Sandigan Bayan in the exercise of its original jurisdiction. For appropriate action, the resolution shall be state the finding of act and the laws of this action. Together with the record of this case, which shall include the warrant if the arrest by virtue of warrant, b. the affidavits, counter affidavits, and other supporting evidence of the parties, c. the undertaking of bail of the accused and the order of the beliefs, d. the proceeding of the preliminary investigation and the order of conciliation, of the resolution of the dismissal of the client within 30 days from receipt of the records. The provincial or city prosecutor or the ombudsman and his deputy, as the case may be, shall review the resolution of the investigating judge when the existing probable cause. The ruling shall expressly and clearly state the fact under law of which basis, and the parties shall be punished thereof of which detained for probable cause was found against him. Section 6. A warrant of arrest may excuse A. by the regional trial court within 10 days from the filing of the complaint or information of the judge. Some personally evaluate the resolution of the prosecutor and its supporting evidence and immediately dismiss the case if the evidence and record will found to establish probable cause. If he finds probable cause, he shall issue the warrant of arrest or commitment order if the accused is already been arrested pursuant to a warrant issued by the judge who conducted the preliminary investigation, or when the complaint or information was proportional to Section 7 of this rule. In case the existing of probable cause, the judge may order the prosecutor to proceed additional evidence within 5 days from notice. An issue must be resolved by the court within 30 days from the filing of the complaint of an information. B. When the municipal trial courts, when the record pursuant to the second paragraph of section of this rule, the preliminary investigation of cases falling under the original jurisdiction and the Metropolitan Court, Municipal Trial Court in cities, municipal trial court, or municipal circuit trial courts may be conducted by either the judge or the prosecutor. When conducted the prosecutor, the procedure is governed by a paragraph within the investigation conducted by judge. He shall follow the procedure provided in Section 3 of this rule. If finding and recommendation are confirmed by the provincial or city prosecutor or by the ombudsman of his deputy, and the corresponding investigation is failed, he shall issue a warrant of arrest. However, without reaching the conclusion of investigation, the judge may issue the warrant of arrest if he finds after an examination and writing under of the move of the complaint and answers that the probable cause exists and that there is a necessity of proceeding the respondent immediate custody in order to frustrate the end of justice. C. When warrant of the arrest is necessary, a warrant of arrest is necessary not issued if the accused is already under the detention pursuant to the warrant issued by the municipal trial court in accordance with the paragraph B of this section of the complaint or information was filed pursuant to Section 7 of this rule. There is an offense